In a particular case before Honorable High Court, a question arose for consideration was whether a person with a pending criminal case can renew their passport. This issue has been addressed by the Kerala High Court and the Andhra Pradesh High Court. These courts have provided significant clarifications that shed light on this complex issue. In a 2024 judgment, the Kerala High Court made several important observations. The court stated that when a crime is under investigation, it cannot be considered that a criminal case is pending against the accused for the purpose of refusing passport renewal under the Passports Act 1967. If the crime is only at the investigation stage, the court held that there should be no restriction on obtaining a passport renewal. In line with this reasoning, the court set aside a magistrate's order that had dismissed an application for passport renewal on the grounds that the offences alleged against the accused were grave and serious in nature. The Andhra Pradesh High Court, in a 2022 judgment, provided further insights into this matter. The court emphasized that merely being an accused in a case does not mean a person cannot hold or possess a passport. This stance is rooted in the fundamental principle of Indian jurisprudence that every person is presumed innocent unless proven guilty. Therefore, the court clarified that the mere fact of a pending criminal case against a person is not sufficient grounds to conclude that they cannot possess or hold a passport. Furthermore, the Andhra Pradesh High Court made an important distinction regarding the application of the Passports Act. It clarified that Section 6 of the Act, which deals with the refusal of passports, applies to the issuance of a fresh passport and not for the renewal of an existing one. The court also pointed out that even under Section 10 Clause D of the Passports Act, a passport can only be impounded if the holder has been convicted of an offence involving moral turpitude and sentenced to imprisonment of not less than 2 years. Both high courts referred to important legal principles and precedents in their judgments. They acknowledged that the right to travel abroad is part of personal liberty, as established in landmark judgments by the Supreme Court. The courts emphasized that the right to possess a passport can only be curtailed in accordance with the law and through a procedure that is just, fair, and reasonable. Notably, in a Supreme Court of India case involving a person whose conviction was stayed, where it was held that the passport authority cannot refuse the renewal of a passport even in such circumstances. So we can conclude that a person with a pending criminal case, one that is still under investigation, can renew their passport. Therefore, mere pendency of a criminal case is not considered a sufficient ground to refuse the renewal of a passport. However, it's important to note that passport authorities should consider each case on its merits, keeping in mind the presumption of innocence and the fundamental right to travel. If you found this video helpful, please like and share it with others. Subscribe to our channel for more legal insights.